Yes, greetings. Welcome back to Kgaka series. Today we have our guest again. I would like him to introduce himself, Prof.
Thank you, Mr. Kgaka. I'm Terence Komal. I'm a medical doctor by training originally. I'm also an extraordinary professor of practice at Northwest University. And I've spent many years, at least the last decade, working in medical legal matters dedicatedly, training in South Africa, the US, Europe, and elsewhere, specifically honing my skills and dedication in the medical legal space. Not because the training and the exposure in South Africa is not adequate, but a lot of what we rely on in the medical world in South Africa is based on guidelines and frameworks out of, for example, Mayo Clinic, Harvard University, and others. Prior to that, I spent a fair amount of time working in clinical medicine, anesthesia. I worked in rehabilitation and significant impairment areas in the military, so I spent more than a decade with government. And I think I wouldn't say for my sins, but I've been blessed by the opportunities as a servant leader to sit in various environments, everything from sitting on the serious injury tribunals at the Health Professions Council, as well as sitting on the board of the Road Accident Fund. So I've been blessed with some exposure to see healthcare, medical, legal, and the personal injury space from the angle of the insurer, the insured, as well as the claimant at the same time.
Sure, this is very exciting. You are really loaded indeed. So you are the relevant person to tell our viewers, our clients, what is a medical negligence.
I would hope so. I think, Mr. Kgaka, as you know, in South Africa, it's developing in an evolving field. Medical negligence in the last 10 years has exploded from where it used to be. And there is, the unofficial talk is the money is drying up in the personal injury space, or it's becoming harder to litigate on contingent matters. But in the negligence area, it's actually booming. What is interesting is, because it's an evolving space, is being able to understand what's negligence and where the liability is. Because many times, as we spoke earlier prior to this discussion, is every patient believes if there's a suboptimal or an outcome that they don't believe was correct or wasn't what they and the medical team expected, then there was some negligence. The challenge with that is, and if I make this metaphorical comparison, the human body is not a machine. Yes, it functions as a machine, but it's not a motor car that you can take to a mechanic, and if the alternator doesn't work, you take it out and put another one. It's not that simple. It's a machine that you repair on the go. You can't switch it off, if you could call it that. It's a living machine. It's a living organism that has multiple interrelated factors. It's not that you're changing a valve or changing a bearing and then now it works, or you change a tire. There's factors of the physical body that affect it. There's hereditary matters, so historical risks. There's lifestyle choices. So you could be diabetic, you could be hypertensive, both due to hereditary conditions as well as lifestyle choices. And then you could also have factors which we call psychosomatic, so mentally caused issues, stress, eczema, the body's reactions, and how you frame your health or your well-being holistically as an individual based on those factors. And then underlying that, we still have the issues of other diseases like HIV and AIDS, TB, malaria, the pandemic like now, COVID. And a lot of that makes an impact on the human body. How you respond to that is very individualistic. And therefore, when one talks about negligence and standard of care and outcomes, you need to understand it's a very complex world. Not every court is competent to understand the detail, therefore the court relies on expert opinion. The court makes a decision on the input provided. But the bar, again, is not at the highest level. In my understanding, there's a famous case that you're an expert on, known as the Van Wyk decision, which says the requirement to test whether someone is negligent or not is what would someone else in his shoes reasonably be expected to do. So the court and everyone in the matter would have to put themselves in the circumstance of the practitioner who acted at that time and first establish, was there negative action? Was there malefides? Did they not act in the best interest of the patient? And even if they did they do what someone else would do or reasonably be expected to do? And that is where there's a lot of confusion. I've had cases where I've had to give opinions because even prior to litigating the matter, I recommend in a lot of the matters to the attorneys and the clients, let's sit down, have a conversation over coffee. Send me the records in advance, we'll go through it, I'll make some notes, we'll have some discussions and have some questions. But what do you want, firstly? What do you want in this claim? You want to sue somebody for damages. what do you want out? If you don't know that, then that's where the confusion is. Okay, you want money, but for the moment you say he caused some permanent damage. Is that money going to help you? Is it going to get you where you were? What would make you feel compensated in broadly? And please, this is not a legal opinion, it's just my experience.
No, correct.
But how would you justifiably be in a position as if you were prior? Or afterwards, what would be ideal? But you've got to then look further. If you can quantify, well, I need R1,000,000 because I can't use my leg as I used to, fine. But then what do you need for your leg? What do you need for your improvement? Because from a clinical perspective, my focus is always the patient. I have zero interest in the outcome of the quantum of damages. My focus is on what do I see, what is the evidence, and is the patient going to get the best treatment? If there was a deviation, I would call on some of my colleagues in the different specialist domains if needed and where needed, and then have a discussion, deliberate on the evidence that's available to say, well, here's what is expected as normal, and here's where it deviated. And to give you two extreme examples, I had one patient that had a spinal operation, and he alleged that the surgeon was negligent because he had a swelling and a bleed that affected his spine and caused a dropped foot. But based on the records of the surgeon, the patient only complained on the Sunday, and within half an hour they booked the theatre and they were there. The patient alleges it happened on Friday, but the evidence didn't support that. I'm not saying the patient was wrong, but you've also got to be realistic. If the entire hospital records and the doctor's records, meaning 5 to 8 people say one thing and the patient says another thing, it's very difficult to counteract that. You've got to be realistic on what you have. And in that case, based on what the surgeon had, he acted timeously, even though the patient's version was different. Then you have another extreme example where you have a doctor who was moonlighting, working in government, worked in a facility north of Pretoria, operated on a patient, went to Polokwane, did a quick operation, worked in trauma. Patient had an injury to a joint, which in this case, without going into the technical detail, that joint needed to be explored in theatre. You need to debride it, you need to clean it, you need to explore and see if there's damage to various structures, and then decide whether to close it up or what else is required. This doctor decided, no, I'll manage it, it's fine, because he was in a hurry to go back to his actual day job. Wiped the patient off, didn't clean the wound, there was still grass and sand in it, stitched him up and sent him home. In that case, the family sued the doctor for negligence. I actually spoke to the doctor and called him up and I said, listen, my friend, outside of the fact that I'm appointed against you as a colleague, what you've done is far substandard.
Sure.
Talk to the family and settle. Do you know he had the audacity to say, I'll see them in court? And he lost, not just for the damages, but the legal cost was more than the damages.
Sure.
So one has to look at the entire spectrum of the ecosystem of negligence. There's a lot that goes into it when you quantify and assess, but you've also got to ask yourself, where do you draw the line of reasonableness? And to a large extent, Mr. Kgaka, you, based on your extensive experience, will know, a lot of times it depends on the judge who's
Correct.
assessing the matter.
Yes.
Outside of, you could bring all of the evidence. It's in the hands of the judge that looks at the matter and decides, I think based on this, that's reasonable. Unless you're able to convince him otherwise with good scientific experience and facts.
We are discussing negligence, medical negligence. We are going to take a short break. Please don't go away. We will come back again. Thank you very much, Prof.
Thank you, Mr. Kgaka.